So good morning, good afternoon, good evening, distinguished guests, colleagues, and participants from across the globe. On behalf of the Hague Conference on Private International Law and its Regional Office for Asia and the Pacific, ROAP, it is my great honor to welcome you all to today's webinar on the 2019 HCCH Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters. I'm Yun Zhao, the representative of the ROAP HCCH. Today, we are privileged to have speakers from diverse jurisdictions who will shed light on the convention itself and its implications. Before we begin, allow me to extend a special welcome to our Secretary General, Dr. Christoph Bernasconi. Dr. Bernasconi's leadership has been instrumental in bringing this groundbreaking convention to fruition in 2019. Mr. Secretary General, the floor is yours.
Distinguished guests, esteemed speakers, dear participants, good afternoon to those of you joining from the Asia-Pacific region, and a warm good day to all those connecting from other parts of the world. Welcome all. It is both a pleasure and a privilege to open today's webinar on behalf of the HCCH, the Hague Conference on Private International Law. Thank you for being with us. We are delighted to bring together an impressive panel of experts from the People's Republic of China, Indonesia, and Poland. Your participation is deeply appreciated, and your insights will no doubt enrich today's discussions and broaden the understanding of the 2019 Judgments Convention, both regionally and globally. If I may, let me begin with a brief word about the HCCH, the organization. With roots stretching back to 1893, the HCCH is and remains the only global intergovernmental organization dedicated to the progressive unification of the rules of private international law, as stated in Article 1 of its statute. We pursue this mandate by developing multilateral treaties, the HCCH conventions, to which states may then become parties. These conventions establish legal certainty and predictability and provide effective mechanisms for cooperation between states in civil and commercial matters. They offer practical and mutual legal solutions that facilitate cross-border interactions for individuals, families, and businesses alike. These HCCH conventions effectively serve as bridges between different legal systems. Yet, at both ends of these bridges, the substantive laws of the states remain largely untouched. That is the true elegance of unifying private international law. The underlying cultural, political, or religious expressions reflected in substantive law are preserved. The HCCH thus enables cooperation without imposing uniformity, ensuring that diversity and sovereignty are respected while making cross-border interaction smoother and more predictable. We work across three key areas: transnational litigation and apostille, international family and child protection, and international commercial, digital, and financial law. Our work connects over 150 jurisdictions, comprising 92 members and more than 60 other states that, while not members of the HCCH, are nevertheless parties to at least one HCCH convention. Let us now turn to today's focus, the 2019 Judgments Convention, our most recent instrument in the field of transnational litigation. As many of you know, cross-border disputes often face significant hurdles, procedural complexity, legal uncertainty, and delays. Some of our earlier instruments, such as the 1965 Service Convention and the 1970 Evidence Convention, have long provided valuable tools for cooperation in this area. But to complete the picture, one also needs a reliable and predictable framework for the international recognition and enforcement of foreign judgments. In comes the Judgments Convention, a real game changer, as I early on called it. It establishes a common framework under which a judgment rendered in one contracting party can be recognized and enforced in another, provided it meets the conditions set out in the Convention. This framework fosters legal certainty, predictability, and trust, three essential pillars of cross-border trade and commerce. By ensuring that judgments are both meaningful and effective, the Convention reduces legal risks, lowers litigation costs, and enables strategic planning. It thus enhances effective access to justice, making it easier for individuals and businesses to navigate cross-border legal disputes with confidence. It is therefore no surprise that the importance of the Judgments Convention has been recognized by the World Bank. In its inaugural Business Ready report, published in October 2024, the World Bank highlighted the Judgments Convention, together with the 1961 Apostille Convention, including the EAPP, the Electronic Apostille Program, as key benchmarks in assessing a country's legal and business environment. The Judgments Convention entered into force on the 1st of September 2023, just 4 years after its adoption, a relatively swift timeline in the life cycle of HCCH conventions. Today, 32 HCCH members, including the European Union, are bound by it. In addition, there are 5 signatory states: Costa Rica, Israel, Kosovo, North Macedonia, Russia, and the United States of America. These developments are indeed encouraging. However, there remains important work to be done, especially in the Asia-Pacific region. As of today, no state from the Asia-Pacific region has yet signed or joined the Convention. That said, I'm aware that steps are being taken in some jurisdictions, and I, for one, am very curious to see which country will be the first in the region to lead the way. But this makes today's webinar not only timely, but also important and necessary. The region's rich legal diversity brings both challenges and opportunities, and this platform gives us a chance to explore them in depth. We will hear regional perspectives from ASEAN states and from the European Union, including Poland, which is already bound by the Convention. I'm confident these contributions will spark further interest and, I hope, inspire action. Before concluding, I would like to extend my sincere thanks to Professor Yun Shao and the team at our Regional Office for Asia and the Pacific, ROAP. Their efforts in organizing this event have been essential in making today's discussion possible. Thank you all once again for joining us. And on that, I wish you a most informative and fruitful webinar. Thank you.
Thank you, Mr. Secretary General. Now, let us turn to our distinguished panel of experts who will explore the Convention's practical and regional dimensions. Our first speaker is my PB colleague, Ms. Melissa Ford, Secretary of HCCH. She will provide us an overview of the 2019 HCCH Judgment Convention. Melissa, the floor is yours.
Thank you very much, Yun, and thank you very much to the Secretary General for your opening remarks. It's a pleasure to join you here today. So I'll provide you with a snapshot of the history of the convention, a brief status update, and then I will outline the framework of the convention. And in my presentation, I'll speak about some key features of the convention, how we determine whether a judgment can circulate. I'll speak about the scope, jurisdictional filters, the grounds for refusal of recognition and enforcement, and I will conclude with a few words about national law. Okay, so the Judgments Project, as we refer to it, has a long history. Many of you joining this webinar will know much about and may have been involved in this history, but for those who don't, it's worth recapping because, as you can see from this slide, the 2019 Judgments Convention was some time in the making. So the Judgments Convention and the project commenced back in 1992 when the United States proposed that the HCCH develop a comprehensive instrument on the jurisdiction of courts and the recognition and enforcement of foreign judgments. So while negotiations on this did result in a draft text in 2001, it proved difficult to achieve consensus on this ambitious convention. However, it was clear that some consensus could be reached, and that was in relation to forum selection clauses or choice of court agreements. And so what was successfully concluded from the start of this work was the Choice of Court Convention for exclusive choice of court agreements. And that was concluded in 2005 and entered into force in 2015. But then you'll see here in 2011, the HCCH again agreed to reconsider a global instrument on matters relating to jurisdiction and to recognition and enforcement of judgments. But in 2013, a decision was made to draft a convention solely on the recognition and enforcement of foreign judgments and move that work on jurisdiction to an experts group once the work on recognition and enforcement was finalised. So we fast forward to the 2nd of July 2019. After 2 weeks of negotiations at a diplomatic session with over 80 participating members and observers, consensus was reached and the Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters was successfully adopted. But you'll see from this slide that the work on the broader project continues. So in 2020, the experts group met again to consider further work on jurisdiction. This project is now being taken forward by a working group, and we have a draft text which contains rules on parallel proceedings, related actions, and a communication mechanism. You can read more about this normative project on the HCCH website. The working group will have its next meeting in October this year, but now we go back to the 2019 convention. And as the Secretary General has already noted, in a little over 4 years, the 2019 Judgments Convention entered into force. So this was a very positive signal for us that it entered into force so quickly. The convention currently has 32 contracting parties. The Secretary General has mentioned it has signatory states, and on the 1st of July this year, it will enter into force for the United Kingdom, and next year in March, it will enter into force for Montenegro and Albania. We also know that other states are actively considering joining this convention, so from our perspective here at the Permanent Bureau, this is very promising indeed. So what do you need to know about this convention and how does it enhance predictability and access to justice? Well, we know that if a wronged party obtains a judgment that cannot be enforced in another jurisdiction where assets are located, in practice, there's no real access to justice. And what this convention does is it fills a gap in cross-border litigation. The Convention establishes a framework for the recognition and enforcement of foreign judgments among contracting parties. And the core element is the Article 4 obligation for a contracting party to recognise and enforce a foreign judgment given by a court of a contracting party, and in accordance with the provisions of Chapter 2 of the Convention. Now, in order to recognise a judgment, a requested court is not permitted to review the merits of the decision of the court of origin. So the court does not reopen the factual or legal basis upon which the court of origin reached its decision. Further, recognition and or enforcement is only possible, the refusal for that is only possible on the grounds specified in the Convention pursuant to Article 7. So that Article 7 establishes an exhaustive list of grounds for refusal. The Convention sets minimum standards for the recognition and enforcement of foreign judgments. National law, particularly where this is more generous, can also be used to recognise and enforce foreign judgments, with one exception, and that is under Article 6. And Article 6 operates as an exclusive basis for recognition and enforcement. And this relates to judgments that rule on rights in rem, in immovable property, and I'll come to that. I would also note that the Convention does not deal directly with jurisdiction of a court to adjudicate disputes in cross-border matters. It's a convention primarily concerned with the recognition and enforcement of foreign judgments, although we will speak about jurisdictional filters during this webinar. States also have some flexibility to tailor the application of the Convention where it's deemed necessary, and the relevant articles in the Convention are Articles 17, 18 and 19. So for example, under Article 18, where a state has a strong interest in not applying the Convention to a specific matter, it can make such a declaration. So the declarations in Articles 18 and 19 should be no broader than necessary, but they do provide some flexibility for states where this is deemed necessary. So how do we determine whether a judgment can circulate under the Convention? We can distill this into three key questions that a user must ask. Firstly, is the judgment within scope? Next, is the judgment eligible for recognition and enforcement? And then, is there a reason to refuse recognition and enforcement? So let's have a look at these key questions and how they're dealt with by the Convention. And the first thing we come to is scope. So this is a private international law convention which applies to civil or commercial matters. It excludes revenue, customs and administrative matters, and there are certain subject matters that are listed in Article 2.1 of the Convention that are also excluded. And they're excluded because they're either already dealt with in other treaties, or they were particularly sensitive matters and where consensus for these matters could not be reached. The Convention also does not apply to arbitration and related proceedings. But let's have a closer look at the types of judgments that do circulate. So the Convention applies to judgments given by a court, and these are decisions on the merits, including default judgments. Judgments can be for monetary or non-monetary relief, so for example, injunctions or orders for specific performance. Judgments can also include costs orders, provided they relate to the merits of a recognisable or enforceable decision. So while costs orders not relating to the merits are not covered by the Convention, there is an exception to this, and that's contained in Article 14.2 of the Convention. Here, if a judgment creditor unsuccessfully seeks recognition or enforcement of a judgment, the costs order against them qualifies for recognition and enforcement, and that can circulate under the Convention. So what about if a requested court is required to recognise and enforce a decision that's still pending review in the state of origin? Well, recognition or enforcement may be postponed or refused if the judgment is the subject of a review of the state of origin, or if the time limit for seeking an ordinary review has not expired. So it's worth noting that in order for a judgment to be recognised and enforced in another contracting party, It must have effect and it must be enforceable in the state of origin. Therefore, a judgment that is no longer enforceable in the state of origin because it has been overturned on appeal should not be enforceable in another contracting party under the Convention. What about parts of foreign judgments that could be recognised and enforced under the Convention? This is also possible. The Convention permits the recognition and enforcement of a severable part of a judgment, and that is pursuant to Article 9. And this might be particularly useful where only part of the judgment is able to be recognised and enforced under the Convention. So, for example, where other aspects of the judgment involve matters that fall outside of the scope of the Convention. So, in order to be severable, a particular part of a judgment must be capable of standing alone. I wanted to touch on issues that could not be recognised and enforced under the Convention. So interim measures such as orders to freeze assets, interim injunctions and interim orders for payments, they're not judgments on the merits given by a court that could be recognised and enforced under the Convention. However, these still might be recognised under national law. Preliminary questions on matters to which the Convention does not apply may also not be recognised and enforced under the Convention. So once we've determined whether a judgment is in scope, the next question is whether it's eligible for recognition and enforcement, and here we come to the jurisdictional filters. So as I mentioned before, the Convention doesn't deal with the jurisdiction that a court has to adjudicate a dispute, but we do have recourse to these jurisdictional filters, and these are contained in Article 5 and 6 of the Convention, and they contain a list of grounds that are considered legitimate bases for recognition and enforcement under the Convention, and we refer to these as the jurisdictional filters. So the court addressed being asked to recognise and enforce a judgment will need to apply these filters to assess whether there was sufficient connection between the judgment and the state of origin that certifies the eligibility of the judgment for circulation under the Convention. So Article 5.1 sets out 13 filters covering general jurisdictional filters, as well as specific filters such as torts, contract, a lease of movable property, non-exclusive choice of court agreements, trusts, etc. The filters that are used are alternative and work on an equal basis, meaning that as long as one of those filters in Article 5.1 is satisfied, the judgment will be eligible for enforcement and circulation under the Convention. In cases where no particular filter under Article 5 is met, recourse to national recognition and enforcement rules of the requested state is still an option, save for Article 6. So in addition to these general Article 5.1 filters that I mentioned, we have some special arrangements for consumers and employees and for claims relating to immovable property. So Article 5.2 deals with judgments sought against consumers and employees, and we have some limitations to the filters that apply here, and that is to provide protection to consumers or employers who have weaker positions in their dealings with businesses or employers, respectively. So here, certain general filters will not apply, including filters covering submission, contracts, and choice of court agreements. Further, Articles 5, 3, and 6 deal with specific claims relating to immovable property, but they differ in their application. And I'd just like to mention Article 6 first. So Article 6 contains one exception to this notion of a floor, not a ceiling, or the minimum standard that the Convention establishes. So Article 6 contains an exclusive basis for recognition and enforcement for judgments ruling on rights in rem in immovable property. So those judgments, according to Article 6, will be eligible for recognition and enforcement if and only if the immovable property is situated in the state of origin. So failing to meet that exclusive filter, the judgment will be prohibited for recognition and enforcement under the Convention, as well as prohibited under national law. So that's an exclusive filter under the Convention. The Article 5.3 filter, which deals with the judgment ruling on a residential tenancy, is a semi-exclusive filter. So it excludes the applicability of the other Article 5.1 filters, but unlike Article 6, the application of national law for the recognition and enforcement of such judgments can be possible. Once we have determined the scope and the eligibility, we have the main obligation now to recognise and enforce. And recognition and enforcement can only be refused on the grounds specified under Article 7. So these are commonly accepted grounds, and Article 7 is exhaustive. So the court addressed is prohibited from applying their national rules to refuse recognition and enforcement. And so these grounds include things like lack of sufficient notice, a judgment obtained by fraud, there is a public policy grounds, the proceedings were contrary to a choice of court agreement, or inconsistent judgments. In addition, the Convention also considers lis pendens in the context of recognition and enforcement as a possible grounds for refusal under Article 7.2. I also wanted to touch on damages. So pursuant to Article 10, the court addressed may refuse to recognise or enforce punitive damages if and to the extent that the award of damages does not compensate the actual loss or harm suffered. So this provision replicates a provision in the 2005 Choice of Court Convention. So recognition and enforcement may only be refused to the extent that the judgment goes beyond the actual loss or harm suffered. And finally, just a short word on national law. As I mentioned, there is still a role for national law. It governs the procedure for the recognition and enforcement. It governs the recognition and enforcement of judgments that are not covered or which would not circulate under the Convention, save our Article 6 exclusive filter. And of course, national law continues to deal with the jurisdiction of a court to adjudicate in the first place. So in summary, we have a convention which establishes the obligation to recognise and enforce foreign judgments circulating between contracting parties with exclusive, exhaustive grounds for refusal. Contracting parties may make certain declarations to tailor the operation of the convention, and of course, where national law is more generous, this can be used and relied on to recognise and enforce foreign judgments. So the 2019 Convention sets the minimum standards that will apply between contracting parties, creating predictability, certainty, and much more opportunity for litigants to have their hard-fought judgments recognised and enforced cross-border. So this convention offers a very meaningful contribution to cross-border litigation, and I thank you for your time. I hope this overview has been helpful, and I really look forward to the rest of today's discussions. Thank you.
Thank you very much, Melissa, for your excellent presentation, giving us an overview of the convention. Now, let us welcome Professor Xu Guojian, a leading authority on private international law and key contributor to the convention's drafting process in China. Professor Xu will discuss China's role in shaping the convention. We are delighted to have you with us today. Professor Xu, you have the floor, please.
Thank you, Professor Zhao Ying, for your kind introduction. Hello to all the experts and friends from different countries joining this webinar. I'm honored to be invited as a speaker at this webinar organized by the HCCH Regional Office for Asia and the Pacific. So the theme of today's webinar is the HCCH 2019 Judgments Convention. The organizers have given today's event a very meaningful title, HCCH 2019 Judgments Convention, Bridging Global Justice. I wholeheartedly agree with the description. the 2019 Judgments Convention is undoubtedly a significant international instrument that has the potential to bridge global justice by facilitating the effective cross-border recognition and enforcement of civil and commercial judgments. Precisely because of its significance, the Secretary General of the HCCH, Dr. Christophe Bernasconi, aptly described the convention as a game changer in the field of international civil and commercial dispute resolution. Earlier, Melissa gave us an excellent presentation on the background and the development of the 2019 Judgments Convention, its entry into force, and the current status of its ratification and acceptance by member states. Her presentation highlighted not only the importance, but also the practicality of this convention in promoting greater legal certainty and access to justice across borders. I would like to point out that the convention clearly set out its mission statement in the preamble, which includes the following goals: to promote effective access to justice for all, to promote rule-based multilateral trade and investment and mobility, the creation of a uniform set of core rules for the recognition and enforcement of judgments, and the establishment of an international legal regime for the global circulation of foreign judgments. It is important to emphasize that the convention explicitly puts forward the concept of the global circulation of foreign judgments. This is an ambitious and far-reaching objective. We look forward to the day when court judgments can circulate freely around the world, just like the US dollar does today. The HCCH 2019 Judgments Convention is a well-structured, logically rigorous, and succinctly drafted international convention. It consists of 4 chapters and a total of 32 articles. Chapters 3 and 4 contain the general provisions and final clauses that are typical of conventions adopted by the Hague Conference on Private International Law. So chapters 1 and 2, however, comprising only 15 articles, form the core substantive part of the convention. The logical structure of these substantive provisions is exceptionally clear and coherent. First, Article 1 and 2 define the scope of application of the convention and explicitly set out matters that are excluded from its coverage. Second, Article 4 establishes the contracting states must recognize and enforce judgments rendered by courts of other contracting states in accordance with the convention. This article is referred to as the cornerstone provision of the convention. Third, Article 5 lays out the jurisdictional basis, also known as jurisdictional filters, on which recognition and enforcement of foreign judgment may be granted. The convention provides for 13 such jurisdictional filters. A foreign judgment must satisfy at least one of these filters in order to be eligible for recognition and enforcement under the convention. In my view, this is the most critical provision of the convention, as it it establishes the international standard, commonly known as indirect jurisdiction, for recognizing and enforcing foreign court judgments. Fourth, Article 7 specifies 6 grounds on which recognition and enforcement of a foreign judgment may be refused. Fifth, the Convention addresses certain special issues related to the recognition and enforcement of foreign judgments in Article 8 to Article 13. These provisions deal with specific and complex matters such as preliminary question, severability awards, of damages, and judicial settlement. These articles aim to provide clarity and consistency in handling such nuanced scenarios, ensuring that the recognition and enforcement process remains fair, predictable, and aligned with the overarching goals of the Convention. By the International Convention, one of the greatest challenges lies in striking a balance between the uniform rules established by the Convention and the diverse legislative and judicial system of its contracting states. The Convention must, on one hand, harmonize the varying legal standards of different countries, while on the other hand, respect the concerns and legal traditions of individual states so as to encourage broad participation and acceptance. The Convention addresses this challenge quite effectively. For instance, Article 13 provides that the recognition and enforcement of foreign judgments shall be conducted in accordance with the procedural law of the requested state. This allows states to maintain their own procedural autonomy. Furthermore, Article 15 makes it clear that the Convention does not prevent the recognition and the enforcement of foreign judgments under national law. This means that the Convention serves as a complementary instrument rather than a restrictive one. Additionally, Articles 17, Article 18, and Article 19 provide for declarations and reservations, allowing contracting states to tailor certain aspects of their participation in line with national interests. In summary, the Convention strikes a thorough and effective balance between the goal of legal unification and the need to respect national sovereignty, legal systems, and domestic concerns. China has actively participated in the negotiation and drafting of the HCCH 2005 Choice of Court Convention. Likewise, China was fully engaged throughout the entire drafting and negotiation process of the 2019 Judgments Convention and made meaningful contributions to its success. China's private international law scholars, as well as judges handling foreign-related civil and commercial cases, have shown great interest and enthusiasm toward the 2019 Judgments Convention. Although China is not yet a contracting state to the convention, it has attracted significant academic attention within the country. Chinese scholars have conducted extensive research on the convention. At the annual meetings of the China Society of Private International Law, as well as in other academic forums, the convention is frequently the subject of focused panel discussions and in-depth debate. At both the legislative and judicial levels, the convention has had a positive influence on the development of relevant laws and practices in China. On January 1st, 2024, the newly revised Civil Procedure Law of the People's Republic of China came into effect. Part 4 of the law introduces special provisions of foreign-related civil procedure. Chapter 27 of this part deals specifically with judicial assistance. Within this chapter, Article 297 to 303 address the recognition and enforcement of Chinese court judgments abroad, as well as the recognition and enforcement of foreign court judgments in China. In the drafting of these provisions, the HCCH 2019 Judgment Convention served as a valuable part of reference. Furthermore, the Supreme People's Court of China is currently in the process of drafting detailed and highly practical judicial interpretations of Part 4 of the Civil Procedure Law. I have also observed that the provisions of the HCCH 2019 Judgment Convention are playing an important role as a reference source in this drafting process. In conclusion, although the HCCH 2019 Judgment Convention has not yet entered into force for China, its provisions have already had a positive impact on China's relevant legislation and judicial practice. Naturally, we hope that China's legislative authorities will proceed with the ratification of both the HCCH 2005 Choice of Court Convention and the 2019 Judgments Convention at an early date. I firmly believe that China's accession to these two important instruments would make a significant milestone in the history of both conventions. We look forward to that day with great anticipation. Thank you for your attention. Thanks.
Thank you very much, Professor Xu. You have given us very enlightening presentations on the convention and also the Chinese situation, in particular with regard to the amendments to the civil procedure law in China. Thank you. Now we are very happy to have Dr. Jacek Kozłowski from Poland, who specializes in providing legal services for investment projects in the energy, construction, and infrastructure sectors in the EU. He will address the application of the Judgment Convention in the EU and Poland. Jacek, you have the floor, please.
Thank you very much, Professor Zhao. Can you see my screen properly?
Yes, we can see. Yes.
Okay, wonderful. So thank you very much. It's a great pleasure to be here again. Thank you for the Hague Conference on Private International Law and the Regional Office for Asia and the Pacific for a swift preparation of the conference, for the initiative, and for giving me the opportunity to speak today on the 2019 Judgments Convention. So we met in Hong Kong in 2023, September. That was a few days after the entry into force of the convention. We were celebrating the entry into force of the convention at that time. And right now, after over a year and a half, I'm very happy to present you the issue of application of the Judgments Convention in the EU and Poland. I will focus mostly on the country of my origin, which is Poland, but I also touch upon some of the practical elements of the application of that convention for the EU. As a practicing lawyer, I was truly hoping to be able to present to you hundreds of cases with in-depths on the interpretation of the convention right now. But don't worry, this time will come. We have to be patient. We are still at the moment where the conference, the convention itself is encountering a growth. Nevertheless, there are some early birds, bringing information about potential cases in the foreseeable future, which I will discuss during my presentation. So for those participants who are from outside of the European Union, I found it useful to tell you a few words about where I come from, and therefore why the Polish perspective might be interesting for looking at the convention. The first reason and the basic information about Poland: we are a member of the European Union, and therefore the convention applies to Poland as a member country of the EU. We have been in the European Union for over 20 years right now. We have a population of over 40 million people, and as you can see from the graph below, we have encountered a tremendous growth in the recent 2 or 3 decades, almost encountering to 400%. I'm telling you that not only because I'm very proud of that growth, but it has some practical implications on how we see the convention or similar instruments of that kind. Because for a number of years, Poland was mainly a capital importing country, focusing on promoting security over foreign investment in Poland, promoting arbitration, promoting enforcement and recognition of arbitral awards in the form of a New York Convention. So in other words, trying to present itself on the global market as a safe harbor for foreign investment and for trade activities. But this is slightly changing in the recent years, and this is why in particular this convention is interesting, because Polish entrepreneurs are more and more interested in expansion into other foreign markets. And this is probably the first time in the Polish history when we are truly looking for instruments which might bring a practical value, especially for small and mid-sized enterprises who are interested in their in security and also cost elements of recognition and enforcement of their potential awards in other countries. So the first message from this slide, and why the Polish perspective is interesting also for those of you who come from the countries which are during the economical transition or economical development, that this perspective change in time. We start with the perspective of incentivizing inbound investments and protections, whereas at a certain point in time, we are also looking into how we can secure our own external activities outside of the country. So this is a specific perspective of Poland right now. The perspective number 2 concerns quite a unique geopolitical and geographical location of Poland, because as you can see, we are the last country of the European Union to the east, and we are the immediate border with Ukraine, which is under the Russian aggression for over 3 years right now. And that also brings some very practical potential implications on how the early cases of the 2019 Judgment Convention might actually go forward. We can see a number of relocation of Ukrainians. So just to recall, Ukraine and European Union, they are party to the convention. They were the first ones who accessed. So very likely that on that verge or that relationship, we will seek for the first cases of application of this convention in practice. When we see at the situation right now in Poland, we can see a relocation of a number of Ukrainian businesses in areas including energy, trade, investment, M&A. And we are already representing a number of Ukrainian clients in disputes with either foreign or Polish entrepreneurs. They are currently being heard by the Polish courts, and any enforcement is done by the Polish courts on Polish assets. But I can see, and as much as I can smell the air here, there will be a growing number of cases, especially for those already well-established Ukrainian companies in Poland, who will be entering into usual economic commercial disputes with the Polish counterparts, and having the decisions against the Polish company given by the Polish court, with the likely enforcement of these decisions in Ukraine. I assume that this will be one of the first cases that we will be looking into. So remember my words, the border between Poland and Ukraine and the economic relationship with Ukraine, between Poland and Ukraine, might be very illustrative for the application of the convention in the future. So these are the two angles which I believe makes Poland quite a unique place to observe and to have a very particular angle on how the convention develops. So when we speak with our clients who are interested in foreign expansion, their main concern surrounds around the issue of costs and money. They talk about the need of optimization of transactional costs. They are afraid of cash flow issues related with potential prolonged enforcement of judgments. They are also afraid of fees of international legal advisors. Therefore, the instruments such as the 2019 Hague Convention, they are actually very compatible with what entrepreneurs from countries like Poland, where the entrepreneurship is to a large extent based on MSMEs. We do not have that many international, multinational, international corporations like you can see in the US or Japan. This instrument might be quite useful in a practical application. So these needs of a Polish business are very interestingly addressed by the goals of the Judgments Convention. I think I will not dwell into details because my learned colleagues who have been presented before me have presented very extensively on what are the goals and what are the particular elements of the convention. But what I would like to say here is that simply the need of Polish entrepreneurs and the solution provided by the convention, they met quite interestingly, or are meeting quite interestingly right now. So if we dig a little bit deeper and deep dive into the Polish system to show you how the legal framework for recognition of and enforcement of foreign judgments looks, it is quite similar to any other European Union country member state. So we have a national level, which is historically, prior to our entering into the European Union, developed autonomously. As a part of the European Union, we are, of course, bound by the Brussels I, which is quite extensively used and is quite a successful instrument in this part of the world. And we have a network of bilateral investment treaties concerning legal assistance and legal relations in civil and criminal matters. We are party to Lugano Convention also, and since 2023, where the convention, the Judgments Convention, entered into force, it applies to all EU member states, so we are also part of that mechanism. So how does it look like in Poland? What are the main issues where we haven't, under the Polish domestic law, which is also used quite extensively and has been used extensively before entry of the Hague Convention, we have the automatic recognition of judgments, so there's no need for special proceedings or issue a sovereign act by the Polish authority, so and no double or triple confirmations of a foreign judgments. There are, of course, possibilities to decide upon whether a judgment should be recognized or not recognized in Poland for multiple reasons, which I will discuss in a second. There are limitations on concerning the changes to the original judgments, and of course, if there are any changes to the original judgments, that change must be reflected when the recognition is sought in Poland. And we have declaration of enforceability, but that applies also to Polish companies which are litigating before the Polish courts. So whenever we have court's decision, which is not final, we have to wait for the a certain period, waiting for the appeal. If there is no appeal, we have to obtain the declaration of enforceability from the court, which is a simple stamp, and then we can go to court bailey and successfully enforce our decision. Yes, we have a separate regimes for non-EU and EU member states, as I mentioned. What are the documents that you have to file in together with recognition? Quite similar to the convention. So official copy of the ruling, a document certifying that the ruling is final. We have to have a certified translation of the document. And if the defendant was not involved in defense of its case on the merits, we have to have a proof of service, which sometimes becomes an issue, especially became an issue during the COVID era when the law slightly changed with regard to service. The sort of legal fiction of service was excluded from the legal system for some time. Grounds for non-recognition, there are a couple of them, number of them are overlapping with the convention. So when the ruling is not final and binding in the state where it was issued, when it falls under the exclusive jurisdiction of Polish courts, for example, concerning real estate, when there was a problem with service, as mentioned in the previous part, lack of defense, the same claim was filed by the claimant before the Polish court already, so we have a respondents. The ruling is against the existing ruling, which is unappealable in Poland, or there are issues related with the principles of legal order of the Republic of Poland, which is a common exclusion from recognition under also New York Convention and under most of national system. So when preparing for this presentation, I was hoping that the Polish Ministry of Justice and the regional courts will provide us with information on what are the actual statistics on, especially inform us whether the convention has been used in practice in any of the cases where there have been any problems with the convention so far. We haven't, we have been informed by the courts that, by the ministry, that they are simply not obliged to make such statistics, therefore they're not being observed. Nevertheless, what we managed to obtain was the statistics of the regional court in Warsaw, that's the biggest Polish court, which is hearing the majority of cases concerning recognition and enforcement. You can see this number is not big, right? We have a few million cases pending before the courts of law right now, and around 27 new cases within the first quarter of within the last quarter of 2024. So this number is not huge. I also tried to get some information from my learned colleagues from Ukrainian law firms, but they were also not aware of any practical applications of the convention so far. So just to give you an update, it seems that we have to be patient and wait a little bit more on the practical application of this convention. So what were the challenges for recognition and enforcement heard by the Polish courts in the past? I think one of the very standard issue concerning punitive damages, as was already mentioned today. So we are, of course, differentiating between recognition and enforceability. Some judgments which could be recognized, not necessarily could be enforced, especially not enforced in full. So the Polish Supreme Court has been hearing these cases in the past, and, for example, found the provision on punitive damages in the judgment of a foreign court not enforced in that part. We had application of public order, which is a usual defense strategy for the other party, which would like to annul the foreign judgment and not accept its enforcement in the recipient state. So we have these cases heard multiple times by the Supreme Court. And also, we had no special facilitations until now, until the convention entered into force. Until entering into force, Polish courts exclusively relied on the Polish Code of Civil Procedure on the application of on the recognition and enforcement of the foreign award. I made this comparison to show briefly what is the scope of application of selected legislations that concern Poland. I think there are no particular findings out of that comparison, apart from the fact that the more stakeholders are involved, the more difficult it is to find a common ground for agreement on what should be included and excluded from the scope of application. As much as you can see that on the national level, quite straightforward, but when an instrument of a global reach such as the Hague Convention applies, then the negotiation process with many stakeholders already makes it difficult to include as many scopes as possible, therefore the exclusions. Apart from the domestic law, as mentioned, we have a group of bilateral investment treaties. Though if you look at the dates in which they were signed, mainly 70s and 80s, these were the times where Poland was under completely different economic and political situation. Therefore, their application and up-to-date solutions, their solutions are not really up-to-date. So I hope that most of these countries will exceed the Judgments Convention, and we will be able to rely on that instrument in the future, not on such a network of bilateral treaties. So what are the prospects for Poland on the convention? Well, of course, as mentioned at the beginning, it's very important for MSMEs, for small mid-sized enterprises, to limit cost and speed up enforcement proceedings in other jurisdictions around the world. And I can tell you that from the perspective of the practicing lawyer, this is probably the only concern that clients are immediately sharing with us when we talk about potential enforcement of any judgments in other jurisdictions. They're afraid of how much cash they will have to inject in that case, whether they can cash flow-wise sustain the dispute, etc. Bearing in mind the high cost of international arbitration, the legal counsels that are involved in international arbitrations, etc. The UK accession to the convention is an important step towards rebuilding and enhancing judicial cooperation with the EU member states following Brexit. It's particularly important for Polish citizens because there are a couple of millions of Poland who left Poland right after we entered the European Union and immigrated into the United Kingdom. We're also a very interesting society of entrepreneurs is growing, and also a number of Polish companies are successfully entering and developing on this market. Of course, an important element is Ukraine. Probably one of the most unpredicted outcome of a horrible aggression and the war that is happening in our eastern border was a growth of Ukrainian entrepreneurship in Poland. And I think particularly for our country, that means that we will be more and more involved in international disputes concerning a daily commercial operation of these companies of that origin. What are the judgment convention challenges? Whether they are universal for us, Poles, or they are universal in fact. But of course, there are a number of carve-outs from the convention application that we've seen in the practice of whether the scope of application will be sufficient to cover the needs of MSMEs and companies which are interested in enforcing their judgments abroad. The success of this convention will depend on the number of countries in which it applies. So as long as unless the system will not become multilateral, we will still to a large extent have to rely on bilateral investment treaties, which you may witness also in your own jurisdictions. A number of these instruments are outdated because we are all waiting for the development of multilateral instruments, and we don't want to involve human and economic resources into working on the instruments that might become not used in the future when the multilateralization will happen in a larger extent. Interim measures do not fall within the convention. They're not qualified as judgments, but that would be very useful. An instrument that is used on a daily basis in any more serious court dispute when both cash flow is involved as well as some kind of a pressure on the other side to fulfill their contractual obligations, a very important thing. And from the purely national perspective, the success or challenges that we'll see concerning convention will also to a large extent depend on where Polish businesses will decide to go. We are mainly anchored into the European Union economy. Most of our business partners are located here, but depending on whether business will go to other places in the world, including, for example, Asia or Africa or Latin America, the law and the need to apply the law in the convention will follow. So I hope you find it useful. I try to give you some of the practical hints or practical observation of how things might look like from this part of the world. And if you have any questions in the future, please feel free to contact me. Thank you once again, Professor Sao, for the organization of the event. And I look forward to hear other presentations. Thank you.
Thank you. Thank you very much, Jessica. It's so nice to have you back, I think, after 1.5 years after your last presentation in our Asia Pacific event in Hong Kong. So I think that thank you for your excellent presentation. Last but not least, we have our old friend, Professor Afifa Kusumadara from Indonesia. Professor, you have the floor. We look forward to your insights.
Good afternoon, ladies and gentlemen. Thank you, Professor Zhao, and thank you, the HCCH Regional Office of Asia Pacific, for inviting me to speak in this webinar. In this webinar, I will speak about the importance of the HCCH Judgments Convention and its relevance for Indonesia. Foreign judgment is not directly enforceable in Indonesia. Parties often have to relitigate in Indonesian courts. The prevailing party in a foreign judgment that needs to collect damages or seek other legal remedies from the losing party in Indonesia has to launch a new lawsuit in Indonesian courts. This can negate the efficiency and finality they expected from their original case. This situation is exactly where the convention becomes relevant. The convention creates a framework for a final judgment from one member state to be recognized and enforced in another member state without relitigating the entire matter. For decades, Indonesia has operated under a principle derived from Article 436 of the Dutch colonial era civil procedure, or rechtsvordering, often referred as RV. This provision effectively states that foreign civil and commercial judgments are not enforceable within Indonesia unless there is a specific law or treaty that dictates otherwise. Unfortunately, Indonesia has no such bilateral or multilateral treaties covering court judgments. Therefore, foreign judgment can serve only as evidence in a fresh trial in Indonesian courts, with different binding effect depending on each case. It could be deemed as an authentic deed that possesses full and binding probative value, or the foreign judgment may only serve as a legal fact, depending on Indonesian judges' discretion. That can be costly and redundant. For example, in the case of Parbulch ES versus PT Humpus Intermoda Transportasi. In this case, Parbulch, a Norwegian shipping company, as the plaintiff, entered into a bareboat charter with Heritage Maritime Limited, a subsidiary of Indonesian defendant Humpus, an Indonesian company. The charter began in 2007. However, Heritage failed to make payments, leading Parbulch to terminate the charter and seek legal remedies. When Heritage did not honor its obligations, Parbold filed for arbitration, resulting in a ruling for over $27 million in unpaid hire. Parbold filed a lawsuit in the English High Court against Humpus for failing to fulfill its obligations under a guarantee, which was issued in connection to Heritage Maritime's debts. The High Court exercised jurisdiction due to Humpus's role as a guarantor under a guarantee agreement that was governed by English law. In addition, Humpus did not challenge the court's jurisdiction after being properly served. In 2011, the English High Court ruled in favor of Parbold, establishing that Humpus was liable for the debts incurred by Heritage. In 2023, Parbold sought damages against Humpus in South Jakarta District Court due to the breach of guarantee and continuous failures to pay as per previous rulings. Because the foreign judgment cannot simply be enforced on its own in Indonesia, Parbold must bring a fresh lawsuit before the Indonesian court, using the English court's ruling as strong and authentic evidence of Humpus's breach. By relitigating the claim and introducing the English judgment as key evidence, Parbold hoped that the South Jakarta District Court would render a new decision ordering Humpus to pay the amounts awarded by the English court and give Parbold a domestically enforceable judgment in Indonesia. At the end, however, the Jakarta court did not decide in favor of Parbold and dismissed Parbold's lawsuit because in their lawsuit, Parbold only sued Humpus but did not sue Heritage Maritime, the Humpus's subsidiary that had the primary charter contract with the plaintiff. The appellate and cassation courts upheld the Jakarta court's decision. So the major objective of the 2019 HCCH Judgment Convention is first, the convention aims to facilitate cross-border dispute resolution by enhances legal certainty. And second, the convention helps to streamline processes. And finally, it bolsters judicial cooperation, making it easier for courts in different countries to trust and rely on each other's ruling. All of these goals resonate strongly for Indonesia, which seeks to modernize its cross-border legal framework and encourage international commerce. An immediate benefit of this convention for Indonesia would be the elimination of the need to relitigate. Right now, if a foreign court has meticulously examined evidence and issued a judgment, Indonesia's court still require the successful party to start fresh. Under the Judgment Convention, if all the conditions are met, such as proper jurisdiction by foreign court and adherence to due process, then the foreign judgment would be recognized here. Equally important, Indonesian judgments would also gain broader enforcement overseas. Another crucial advantage is legal certainty. And then there is an access to justice aspect here. By cutting out redundant legal proceeding, the convention reduces the cost and the complexity for the winning party, including smaller businesses or ordinary citizens who cannot easily afford lengthy transnational litigation. And then by ratifying the convention, Indonesia would demonstrate that its courts are prepared to align with international standards. Consequently, Indonesia must improve the quality of Indonesian courts. The convention can serve as a powerful tool for bolstering Indonesia's investment climate. It also helps improve metrics like the World Bank's Business Ready, formerly known as ease of doing business, or similar other indicators that emphasizes on the efficient dispute resolution. One key challenge of the convention's implementation in Indonesia is to harmonize Indonesia's domestic law with the convention's rule. In 2024, the Indonesian government, in this case the Ministry of Law, has submitted the Bill of Indonesian Private International Law to Indonesian Parliament. The bill contains a chapter that governs recognition and enforcement of foreign judgment. Article 65 of the bill governs that foreign judgment that are condemnatory in nature must be enforced under reciprocal international treaties between Indonesia and the state of origin. However, the bill has not been discussed in the parliament, and the bill still needs to include frameworks that map onto the convention provision. At the moment, the bill is still pending in the parliament. Another area of challenge is judicial readiness. Judges and court staff would need training on new procedures, including how to verify foreign judgment, how to determine jurisdictional validity, and how to apply refusal grounds correctly. Indonesian Supreme Court might have to issue new guidance or regulation, similar to what was done for foreign arbitral awards under the New York Convention. These logistical steps are crucial so that when foreign creditors walk into an Indonesian court with a foreign judgment, local judges know exactly how to handle the application. And then a few steps appear essential here. So first, Indonesian lawmakers must need to be convinced that the benefits of ratifying the convention outweigh any perceived downsides, such as the convention exception for things like fraud, public policy, and lack of due process. An adequate safeguard must be given attention to protect Indonesian sovereignty and public interest. Second step is that to pass the private international law bill, and then to sign and ratify the convention through the usual legislative and executive process. And finally, the Supreme Court might then issue implementing regulation to clarify the details. And finally, judicial training across all relevant courts and legal professionals to ensure proper handling of foreign judgment must be done. In conclusion, the Judgment Convention provides a solution to the long-standing challenge that Indonesia faces in recognizing and enforcing foreign judgment. The benefits of the convention include reciprocity and enhanced legal certainty. By acceding to this treaty, hopefully we could modernize our Indonesian civil judicial system and improve our international standing in trade and commerce. Therefore, we must tackle the necessary legislative reforms and build the capacity within our judiciary system. Thank you for your time and attention.
Thank you very much, Professor Kusumadara, for your excellent presentation, I think, which give us very clear pictures about the situation in Indonesia and also its relationship with the Judgment Convention. More importantly, you emphasize a critical role of capacity building in Southeast Asia, in particular Indonesia. So, ladies and gentlemen, we have had 4 excellent presentations, and thanks to our 4 speakers for sharing your profound expertise and diverse perspectives. Now I think we will, probably only have time for one question, I'm afraid to say. I think we have some questions. Probably I will pick up only one, if you don't mind, regarding the understanding of close connection in Article 7 of the HCCH Judgment Convention. I think the question basically asks, how should courts interpret the notion of a close connection under subparagraph B of Article 7 when assessing the existence of a parallel proceedings in the requested state. Can such an assessment be made solely under domestic law, or should it be guided by uniform standards or international practice? So I think this is a question regarding the understanding of close connection in paragraph B of Article 7, whether we should assess close connection under domestic law, or is there any international practice or uniform standards? I'm not too sure whether any panel members will be willing to respond. I can see that Melissa is ready. Thank you.
Well, I would just say that in terms of the close connection, that the convention doesn't determine which bases of jurisdiction meet this close connection condition. But I guess in terms of interpretation of the convention, there needs to be an international interpretation of the convention over time. So I think this could be one of those factors that would be developed over time and could be looked at as the convention starts to be interpreted and used by contracting parties. But I'm not sure if my other members wish to add to that, but that is certainly something that the convention doesn't specifically articulate.
Thank you, Melissa. So any other views from the panel members? I think basically, Melissa, I think you pick up the right point. I think that part, yes. So thank you very much. So because of the time constraints, I think probably we will stop here regarding the Q&A segment. If you have any other questions, please feel free to email us. We can channel to our panel members and give you the answers afterwards. And so I hope this will be fine for all of you. Thank you very much. Now, ladies and gentlemen, it is my great honor to conclude this remarkable webinar today. Within 1.5 hours, we have engaged in vibrant discussions about the 2019 HCCH Judgment Convention, a landmark instrument that promises to reshape the global enforcement of civil and commercial judgments. It is also my responsibility to extend my deepest appreciation first to Secretary General of the HCCH. Thank you very much for your visionary leadership and for framing today's dialogue with your profound insights into the convention's role in shaping the future of international justice. To our distinguished speakers, my dear colleague, Ms. Melissa Ford, Professor Xu, Dr. Jesek, Professor Afifa, your expertise has illuminated the convention's practical and theoretical dimensions, bridging perspective from Asia, Europe, and beyond. To all our participants, your engagement has enriched this discussion. The Asia-Pacific region's diversity of legal systems makes your contributions invaluable as we move towards broad ratification and implementation. Last but not least, I would also like to thank my colleagues, the ROAP colleagues, Ms. Junbo Song and Ms. Shelby Chan, for their hard work. Ladies and gentlemen, the 2019 HCCH Judgment Convention is nothing short of a legal revolution. By establishing a unified framework for recognition and enforcement of foreign judgment, the convention eliminates the need for cumbersome domestic reviews, fostering trust among nations and ensuring justice across the borders. While the convention makes a historic milestone, its true potential lies in widespread ratification and implementation. So ladies and gentlemen, I believe this webinar on the 2019 HCCH Judgment Convention is not an endpoint, but a beginning. The ROAP We'll continue to strive for close collaboration with all stakeholders in our region and beyond to ensure the universality, inclusiveness, and effectiveness of this convention. We look forward to working with you in the future to advance our shared goals. Thank you for your active participation and valuable contributions. Before I end my remarks, please kindly help to fill in the evaluation form so that we can further improve our work in the future. Thank you very much. With this, I conclude today's webinar. Thank you very much.